Greetings. Testing A, testing B, testing 1, 2, 3. Testing, testing. Check, check. Check. Testing A, testing B, testing 1, 2, 3. All right, sounds like we get good sound. Everyone's there. Let's get the party started here. And today we're going over trust, creation, powers, and intentions of trust. And we're getting all this information today from American Jurisprudence with assistance from Black's Law Dictionary, 9th edition. And let's get things started. So what we're going to be going over today is American Jurisprudence, 2nd edition. This is from August 2011. So it's over 20 years old. Excuse me, over 10 years old. But the principles in here apply really mostly today. And there's some new rules that were introduced in 2000 that are covered well in here. And again, nothing here is considered to be legal advice or anything lawful for action for you to use at all. This is strictly for entertainment purposes and educational experience of just reading into American jurisprudence in general. And please don't take this as any kind of advice or do this at home. All right, let's continue. So today we're going over starting at section 18 on the creation of trust. Comment note, creation of express trust in property to be acquired in the future is referenced in this volume here. And let's continue here. We have some forms that we would also be able to reference here, but we're going to get right down to the meat of it. So you have deed pool creating trust, inter vivos trust agreements, form drafting guide. So the good thing about American jurisprudence is they give you everything you need to do involving practicing law. Okay, I'm just trying to find where we should start here. I think we're going to start right here on modes and restatements. Now, again, what is a restatement of the law, sometimes abbreviated as? And as we looked up, and I'll just start briefly in Black's Law, we can find out exactly what it is. And I'm just going to get into a brief part of it because we looked deeply into it. But it's one of several influential treatises published by the American Law Institute. So it's I guess treatises are just writings of instructions here, and it's of the American Law Institute, which is a private organization, and a law given an area guiding its development. But what you want to say about a restatement of law, right? Undertaking what an organization should undertake. It's the work is a restatement, and its object is to make certain much that is now uncertain, simplify unnecessary complexities, and also to promote changes. And this is the best part here. Focus on this. This is the intention, to better adapt the laws to the needs of life. Needs of life. Interesting. So that's our intention of a restatement. So let's continue. So back to our restatement here. Oops. There we go. This is restatement third on trust. Was referring to section 10. So, except as prevented by the doctrine of a merger, a trust may be created by 1. A transfer by the will of a property owner to another person as a trustee for one or more persons. So let's focus on this. Number 1, trust may be created by a transfer of the will of a property owner to another person as trustee. So the other person it's being transferred to is the trustee for one or more persons. So the transfer, remember, the equitable title will be to the trustee. Beneficiary gets the legal title. Transfer inter vivos by a property owner to another person as a trustee for one or more persons. So let's look at this one. A transfer inter vivos, so that means in the living, between living entities, I was people, persons, but it's while they're living, not because of someone being dead, by a property owner to another person as trustee, again, for one or more persons. So it's being held in trust for these people. Declaration by an owner of property that he or she holds that property as trustee for one or more persons. Interesting concept. So a trust may be created by, except as prevented. So we got to see if there's anything preventing us from doing this. But it could literally be declaration by an owner of property. I own the property, but I'm holding the property as a trustee for these people, meaning that I may own the property, but I'm only holding an equitable title, and the legal title is held by one or more other persons. An exercise. Now, hang on. Do these one or more persons need consent? We'll look into that. An exercise of, all right, this is number 4. This is a fourth way we can create a trust. Because remember, we're talking about creation here. Fourth way is an exercise of a power of appointment by appointing property to a person as trustee for one or more persons who are objects for the power, or 5. Yeah. 5. A promise or beneficiary designation that creates enforceable rights in a person who immediately or later holds those rights as trustee. So a promise or beneficiary designation. So it's a promise. So again, let's stay on focus. We're talking still about how you can create a trust. And we're on the 5th and final way. So this is probably the most complicated. So let's focus here. It's a promise. It's created just by a promise or beneficiary designation, whatever that may be, that creates enforceable rights in a person who immediately or later holds those rights as trustee, who immediately or later holds those rights as trustee, or who, pursuant to those rights, later receives property as trustee for one or more persons. If anyone understands that better than me, please leave something in the chat, because this one looks pretty complicated, but I bet it's not, because, again, the purpose of this kind of law and these restatements of law are to make the unnecessary complex simple. And things that are necessarily complex are going to remain that way and be precisely documented. So I like to take everything into account here. So we'll revisit this, I'm sure. But remember, we could create a trust. This is one I still have questions about, unless someone else could give better clarification. But it's just created by a promise or a beneficiary designation. I'm designating you as beneficiary. That's going to create enforceable rights in a person who immediately or later holds those rights as trustee, or who, pursuant to those rights, later receives property as a trustee for one or more persons. Very complicated there. But let's see what we get in the practice guide, though. That's the beauty of American jurisprudence. We get some good tips usually after this type of curveball. Practice guide. The recommended practice for establishing a trust is, pay attention, get your number Esquire pencil, to execute documents of transfer along with the declaration of trust, as the transfer documents help to prove that the settlor intended to create the trust. Wow. Now look at this tip right here. Recommended practice for establishing a trust. So we're talking about creating a trust. We went over 5 different ways we can create a trust. And now we're looking at practice to put it in a practical use. When we're establishing a trust, recommended practice is to execute, verb, execute documents of transfer, along with the declaration of trust. Because remember, the trust has to be that declaration. Can't just be an empty promise, but has to be declared somewhere. As the transfer documents help to prove that the settlor intended to create the trust. So this is an interesting element, and we'll look back into this. A transaction failing as a gift may give rise, irrespective of such failure, to a trust, where it complies with all the essential and requisites of a trust. In some instances, an express trust may be affirmatively created and declared by a court as, for example, were created by a divorce court to secure payment of alimony or child support awards. So an express, remember that's one where it's got a definite time for being executed. It's going to happen. It's not waiting for something to happen. So when it's created by a divorce court to secure payment of alimony, right? Observation. A court cannot impose a trust where the parties have contemplated another relationship, although a court may impose a trust when none exist to effectuate the party's intent. So you can't say that there's an effect of their intent without another relationship being contemplated. Interesting. So you need to have that contemplation entered as evidence for it to exist as something that would effectuate, have an effect on having the party's intent being valid. All right, so consideration as a rule is, as a rule, necessary to a binding promise or contract to create a trust or, in the future, to convey or transfer property in a trust. So that is kind of a contract, a binding promise or contract. So consideration is, as a rule, necessary. As a binding promise or contract. So either one can create a trust and convey or transfer property. Remember, by having a good practicing guideline here is to execute documents of transfer along with your declaration of trust. So that's for establishing one. So this is something to consider. If you're not sure exactly how or what that means, we'll look into that deeper. That's footnote 2. And that's Taliaferro versus Taliaferro. So it looks like a divorce. 1996, Kansas. So we could always look at that one at some other point in time. But I just want to get through this part here. Let's continue. A trust will not be created where none in fact was contemplated. Okay, that's 2002 and 2003. So let's continue. We're on to 19, the purposes of trust. A trust, to be valid, must have a purpose. In order to create a trust, the words or acts of the person who allegedly created the trust must indicate its purpose with reasonable certainty. The purpose of a trust governs its administration and enforcement, and such purpose is determined by examining the language of the trust instrument and the surrounding circumstances. So the purpose of a trust governs, regulates its administration and enforcement. The purpose will have to govern and regulate that. And such purpose is determined. How do we determine the purpose of a trust? By examining the language of the trust instrument and the surrounding circumstances. Footnote 2, 1990, Iowa, as to construction of trust. In the absence of a statute to the contrary, remember, we always have to look in the jurisdiction that we're operating in because this is, to some extent, commercial, right? So if there's statutes that are contrary to what you have in your instrument, trust instrument, a settler, the person that's organizing the trust, may create a trust for any lawful purpose. Good language here, guys, to pick out on. And the trust may be created for the settler's own benefit as well as the benefit of another. The material purposes of a trust are subject to the settler's discretion which is limited only to the extent its purposes are lawful, not contrary to public policy, and possible to achieve. Right. Welcome, Chosen. We're on to the really good stuff here because we're talking about creation and the purpose of trusts. So this is really where we're learning some actionable stuff here. Not that any of this stuff is advice in any way, shape, or form. It's just for entertainment purposes, and do not try this at home. All right, let's continue. Let's read this one more time. So in the absence of a statute to the contrary, notice we start the paragraph with this. Can't overlook this, that you need to look into your local statutes or whatever jurisdiction you're operating the trust in. Because remember, that court is where you're going to enforce both the civil and the equitable aspects of it, if necessary. A settler, remember the person that's designing or structuring this, right, may create a trust for any lawful purpose. Key word, lawful. And trust may be created, for the settler's own benefit as well as the benefit of another. So the person designing the trust, it could be for their benefit as well as for another, which would be, of course, beneficiaries. The material purposes of a trust are subject to the settler's discretion. Material purposes. Think about that. To the settler's own discretion, which is limited only to the extent its purposes are lawful, not contrary to public policy, and possible to achieve. And then we're back to this Uniform Trust Code, that was 2000, which provides that a trust may be created only to the extent its purposes are lawful, not contrary to public policy, and possible to achieve. Also adds that a trust and its terms must be for the benefit of its beneficiaries, and also provides that the requirements for a trust's creation, including the requirement that a trust have a legal purpose, are controlled by statute and common law, not by the settler. Interesting. So you can set terms of the trust, but only within the constructs of the law, both statutory and common law. Accordingly, the terms of a trust do not prevail over the requirement that a trust have a legal purpose. So that's an interesting. The terms of the trust do not prevail over requirement that a trust have a legal purpose. So we're back to purpose. We're focusing, remember, this chapter is on purpose. So if we consider that the legal terms of a trust do not prevail over the requirement that the trust have a legal purpose. Now, here's something that's interesting. Uniform Trust Code, trusts have a legal purpose. However, we see here that lawful purpose. Legal purpose when we're referring to the Uniform Trust Code, but lawful purpose when we're referring to statutory and common law. So just a little observation of my own here I want to point out. We haven't seen this word legal yet until we started talking about these guys, the Uniform Trust Code, and I believe that was 2000. Perhaps it's in footnote 5. Yeah, well, it doesn't have the year, but. So, interesting things to be aware of as to trusts contravening law or public policy, of course. So that was 2004. So you see the stuff is already creeping into our common law. So, trust contravening law or public policy. Now we're going to get into this, and I think it behooves us at this point to look up a word like contravening. Give me just a second here. Contravene. Is it on screen? Yes. To violate or infringe. To defy. Soldier contravened the officer's order and then went AWOL. Violate or infringe is to contravene, to come into conflict with, to be contrary to. The court held that the regulation contravenes public policy, comes in conflict with, right? Contravening equity, contravention. So, okay, so I think we get that down pretty well. Let's return. Okay. So again, we're looking at trust contravening, conflicting with the law or public policy. A trust must have a lawful subject matter. Generally, where the object of a trust is to circumvent a statutory prohibition or defeat a public policy, the trust is void and of no effect. And one who wishes to dispose of his or her property through the device of a trust must do so subject to considerations of policy, and a person cannot force the courts to sanction his or her scheme of disposition if it is inimical to the interests of the state. So, it follows that the criminality of purpose ordinarily voids a trust. However, the illegal motives of a trustor, where his or her method is legal, do not generally affect the validity of a trust, although certain motives, such as evasion of taxes, may cause the court to resolve doubts against the trustor. Furthermore, a trust executed by illegal means need not fail if the trust could have been executed by legal means without defeating the settler's purpose. And remember, we would establish purpose according to what we read in the last chapter or section. The view has been taken that public policy is not violated by a trust provision for loss of any benefit under a testamentary trust upon adoption of the beneficiary by a non-member of the testor's immediate family. The public policy is not violated by a trust provision for loss of any benefit under a testamentary trust upon adoption of the beneficiary by non-member. Okay, well, that's footnote 7. National Bank of Commerce versus Greenberg in Tennessee, 1953. So that's probably a good case to read, 1953. Okay, so caution. Remember, we're reading American jurisprudence, and part of being prudent is to understand the cautions and the threats. This view has been expressly rejected where, codicil. So codicil, 15th century, a supplement or addition to a will, not necessarily disposing of the entire estate, but modifying, explaining, or otherwise qualifying the will in some way. When admitted to probate, the codicil becomes a part of the will. Right, so it's a supplement or addition to a will, not necessarily disposing of the entire estate, but modifying, explaining, or otherwise qualifying the will in some way. So it's not necessarily disposing, it's when admitted to probate, the codicil becomes part of the will. So let's read this, because we need to know what a codicil is in its intent and purpose. That's why we're doing this. A schedule or supplement to a will or some other writing. Get that off screen there, okay. Or some other writing. Some writers conferring a testament and a codicil together call a testament a great will and a codicil a little one, and compare a testament to a ship and a codicil to the boat tied to the ship. Wow. You get that? So the will and testament is the ship, and a codicil is the boat tied to the ship. A codicil from codicillus, a small codex, a little book or writing, may be defined as a writing by the testator intended as a supplement or addition to his will, the effect of which may be either to enlarge or restrict it, or to annul or revoke it altogether. It may add to or subtract from provisions of the will. It may explain or alter, confirm or revoke them wholly or in part, or, when the will itself is invalid, may be a valid re-execution and republication, revive and renew the will. A treatise on the law of wills, 1900. So the codicil. Look what a codicil can do for a will. Interesting stuff here. It says here, the effect of which it may be either to enlarge or restrict, to annul or revoke altogether, may add or subtract from provisions. It may explain or alter, confirm, revoke, wholly or in part, of a will. And when the will itself is invalid, the court decides it's invalid, the codicil may, by a valid re-execution and republication, revive and renew the will. Holy goodness. So, yeah, pretty interesting insight here from a definition, a supplementary edition. But now when we understand what that little supplement edition can do, it's not just a little boat. It's a big deal. So words have meaning in one sense, but the appropriate level of precision of applying that meaning in this context of trusts, we can see where a codicil could be an important part. So let's find out where this ties in now. This view. Okay, the view has been taken that public policy is not violated by a trust provision for loss of any benefit under a testamentary trust upon adoption of the beneficiary by a non-member of the testor's immediate family. So this looks like, yeah, okay, so a will. This view has been expressly rejected where a codicil, which added a condition to a will that if particular persons were named and appointed and acted as either the guardian of the person or the guardian of the estate of any beneficiaries of a trust for children, all funds and all property held in trust for the beneficiary would revert and become a part of the trust for a different beneficiary was deemed void as against public policy, since it sought to forfeit the estates minor children because of an action taken by the probate court in their best interest. Wow. So we can see where a codicil, all funds, right, was deemed void. It's against public policy. So the codicil is powerful, but it can't go against public policy in this context. Let's continue here. We have something. Florida, 1927. Ooh. That's footnote 1. A trust must have a lawful subject matter. Great. Hey, welcome, Nubs. Glad to see you here. Learning about trust creation, and right now we're on to the purposes. And now we're looking at certain things where there's conflicts with public policy. This is what we are, contravening law or public policy with trusts. So these are ways that a trust could be invalidated by law or public policy. And we're also looking at some of the case laws that have supported what we're talking about here. And again, we're getting a little bit, sometimes we're getting into complex things, but when you think about a codicil, and if you weren't familiar with what one is, now you certainly do know, and probably at depth, because we've looked at it in the context of this case where it's actually become invalid. But when we look at the definition, It actually has a lot of force involving a will, to the point it could do everything from revoke it to revive it. So these functions of these words end up being much more far-reaching than just what they seem to be, even in their etymology. But in their purpose and meaning, they become much deeper. All right, now we're on to the impossibility of performance. Present impossibility of performance of a trust, or the impossibility of a particular mode of performance, does not necessarily prevent a trust from arising or call for the termination of a trust, at least where deviation from the terms of the trust, in order to accomplish the ultimate purpose of the trustor under a decree or order of the court, is justified. Wow. Impossibility of performance works a failure of the trust. However, where performance is material to the very existence of the trust, and where no justifiable deviation from the terms of the trust can make a modified performance possible. Wow. So this is pretty, this looks like stuff where you have to really read in this case. 1933. Stack's will, Wisconsin. John's will, recalled on grounds. Let's see here. So, okay, so we got some pretty deep stuff here on this one, but let's move along with the, this again was the impossibility of performance. You need to further research into this case text here to understand probably a little bit more detail about this. Here we go. As to a rule where a trust instrument shows intention that the trust should be created in a certain manner and in no other. So that's footnote 6. And that's getting here to where no justifiable deviation from the terms of the trust can make a modified performance possible. Impossibility of performance works as a failure of a trust. No justifiable. Okay, that's nice. Yeah, you never know until you try, huh? Ain't that the truth? All right, let's continue here. All right, moving ahead, we're on to section 22 here. Effect of provision for forfeiture by contesting beneficiary. No contest clauses. So we're going to get into this here. And of course, we had some forms here through American jurisprudence. The beauty of American jurisprudence and why you see bookshelves dedicated to these volumes here is because of the value that they bring to anyone that has to practice anything involving these courts. Yeah, well, you never want to have preparation for failure, that's for sure. But I always say that preparation is the best form of prevention. So the more prepared we are for this, the more we're preventing the pitfalls. All right, let's continue. So, forfeiture by contesting beneficiary. A trust instrument may validly provide for forfeiture of the rights of any contesting beneficiary. Further, it has been stated that a no contest clause in a declaration of a trust is valid and must be given effect according to the intent of the trustor, as that intent appears from the terms of the instrument itself and surrounding circumstances. Remember the surrounding circumstances. So yes, that intent appears from the terms of the instrument itself and surrounding circumstances. Again, back to the intent of the trustor. And just in case we want to make sure we know what the trustor is, because we get interchangeable terms sometimes in here, and I also want to make sure that we're very clear on these. You see here, should be able to get us trust. So a lot of trusts. You just want to get to the word trustor. Find exactly if we're using a almost there, guys. Trustee. Ah. So gonna give me trustor. That's weird. Oh wait, trustee, trust. Gosh, I hate this book the way it is here. Um, I didn't see trustor. Thanks. That's what I thought it was. I'm just making sure there wasn't another legal definition of it in here, because that's a pitfall that I find, is that sometimes they use it interchangeably, and it is when it gives property to settle it on the trustee. So yeah, so this is the one of the. Let's move along here. Okay. Oops. Back to AmJur. Okay. That the intent appears from the trustor, right? From the terms of the instrument itself and surrounding circumstances. Let's see what we get going here. Sorry, it doesn't fully fit on screen, but let me read it out there. So effectively, I can set up a trust between me and my business partner and be able to operate in a different capacity. Correct me if I'm wrong, please. I believe if it's a lawful purpose and it's structured within the terms of the trust, I don't know enough about it to tell you, but it seems to me that there's nothing that would prevent you from doing that. I would look into it deeper. Again, and what we're going through here, there are all these little footnotes here, and I don't go into them in detail here because it would be too much for the stream. But I am going over them. You're seeing them here. When I go to the end of the chapter, I am scanning over them. You can always look these up. Footnote 1 is this Berry versus American Security and Trust. So you can always use screenshots of this and see the case and look them up yourself and whatever it may be. So let's look at this observation, which is another beauty of American jurisprudence. We get these tremendous observations here. Although a no contest clause in a trust is enforceable, it will be strictly construed. And no contest clauses in inter vivos trust, remember these are the ones that are living in between living people, are not to be extended beyond what was plainly the settler's intent. A forfeiture of a trust is to be enforced only where the trustor intended that the beneficiary's conduct should forfeit the beneficiary's interest under the trust agreement. Wow. So let me see this here. Oh yeah, that's a good one, right? Yeah. Oh, I can just tell you, it's just magic. It's with the magic wand at the judge, it'll work. It can be the beneficiary. Archangel says, yes, you can be the beneficiary or the agent or the trustee. You just can't be all of them. That's for sure. You can't have a sole entity playing that role, person, whatever, playing the role of all three of those. Cumulative supplement cases. Okay, so we have a little case here. Let's check this one out here. This is 2010, so this was pretty recent when this was released. Whether there has been a contest within the meaning of a particular no contest clause depends upon the circumstances of the particular case and the language used. Remember, we get to the language of the instrument. That was the way we were able to evidence the intent. was the language. So this is our intention, right? And then from there, we also have circumstances of the particular case. So remember these two standards we looked at before: circumstances, surrounding circumstances, and the language of the original trust instrument. Oh, this is the whole point that we're getting over here, Nubs, is that what we're getting at is that we're just getting, not saying what you can't or can do, but what are the elements required. As long as you're meeting those requirements, it doesn't matter what language it's in, as long as it can be interpreted by the parties that are involved. I think, English might be a good idea to start with, since we're in American courts here. This is American jurisprudence we're talking about. And I think the key of this is that, again, I want to get back to the definition that we talked about here of a restatement, that what we're reading here are restatements of law. Again, what a restatement is, it says it here somewhere. But a lot of what we are referring to here are restatements of law. And the restatements are to let the laws, to help aid in adapting the laws to the needs of life, and essentially to eliminate unnecessary complexity and to explain certainty where there's much uncertain. So the more you can clarify the uncertain, the more you can simplify the unnecessary complex, the more you can help the laws adapt to the needs of life in the language you use. I think you're going to be meeting every requirement of a trust instrument, in my opinion. So Archangel asks, so there can be a dispute, but it must be about the language and not the terms or conditions of the trust. Terms and conditions do play a role. They both do, the language and the surrounding conditions. So those both have to be considered in any kind of dispute. And we're saying here, not necessarily good things, but things nonetheless. Yeah, I'm not going to make judgments on good or bad, but when there are certain complexities necessary, some that are unnecessary where things have just gone wrong, and it's up to us to know the difference and where to apply for an appropriate level of precision, especially when we're considering something as important as the law. All right, let's continue here now. So we're moving ahead. I think we fixed this pretty good. So the effective provision of forfeiture by contesting beneficiary in the case of wills. So it's construction of trust generally. All right, so now we've moved on to section 23, multiple trusts. So let's look at these multiple trusts. We have joint revocable trust, division into shares, consolidation of trust with subsequent trust. We have the forms for doing all this stuff. So again, if you're interested in seeing some good forms for doing this, you just look into these volumes of the American Jurisprudence, Legal Forms, second edition, Trust, section 251, 65. So there it is. It's all in there. I mean, I could pull that stuff up here too, but I think I would lose. We've got 6 people in the audience. I think we'd lose everyone pretty quick if I started going that deep into it. But those forms are available for you to use. It's not like a big secret. You can probably get this stuff from most of your university law libraries if they still have American Jurisprudence. You can always get a subscription to some of the online services. I think Westlaw is a good one. All right, so let's continue here. So again, we're about to go over multiple trust on section 23. Where a first trust is already in existence, there are 2 ways to create a valid second trust. Okay, 2 ways to create a second trust. As either all the beneficiaries of the initial trust can make a second trust of their equitable interest, or the trustee of the initial trust may consent to the creation of a second trust. 2 ways. Okay. Either all the beneficiaries of the initial trust can make a second trust of their equitable interest, beneficiaries of their equitable interest. or the trustee of the initial trust may consent to the creation of a second trust. Wow. The Uniform Trust Code provides that after notice to the qualified beneficiaries, a trustee may combine two or more trusts into a single trust, or divide a trust into two or more separate trusts if the result does not impair the rights of any beneficiary or adversely affect achievement of, again, purposes of the trust. Yeah, so that's some pretty deep things here when we're looking at this. Splitting trust, combining trust, as long as you're not doing anything that would impair the rights of any beneficiary or adversely affect achievement of, again, purposes of the trust, which is the primary reason for the existence of a trust. Separate and several trusts to be administered by the same trustee may also be created by the same instrument. Wow. So within the trust, you could have other trusts being administered by a trustee of that trust. In line with the basic rule that to construe a trust, one must first determine the intention of those creating the trust. In determining whether one or multiple trusts are created by an instrument, the particular words of the instrument creating such trusts or trust must be examined to determine the creator's purpose. So again, determining the creator's purpose, the intent of the trust to begin with, the language used was supposed to be evidence of this. So again, we would examine, remember, was examining the language when it must be examined. We're examining the language as we read earlier. So let's be clear here. Particular words. See, they're just saying this in a different way. Creating such trust must be examined. Instead of just saying language, now we're getting even more detailed. The particular words of the instrument creating such trust or trust must be examined to determine the creator's purpose. Particular words, the language. In this regard, where a trustor used such plural expressions as trust estates, trusts, said estates, trust funds, several trust estates, and respective trust estates. Wow. The trustor indicates that he or she has in mind not one, but several trust estates. Provisions in the trust that the trustee keep accounts with all the beneficiaries separately may also indicate an intention on the part of the grantor to create separate trusts. Interesting stuff here. As to whether a trustee is under a duty to set up a single trust or several trusts. See section 448. Reservation of powers by settlor, generally. Right. Getting a little over that hour mark. I want to make sure everyone's still with me here. If you are, please hit the like. And let's continue. A trust is valid even if the settlor retains extensive control of the trust property. Moreover, a revocable living trust is valid even though the settlor reserves an extensive power of control over the administration of the corpus, dead body. The grantor of an inter vivos trust may retain some rights, such as the right to receive trust income or the right to revoke the trust. However, where the powers retained by the settlor amount in cumulative effect to the ownership of the trust estate, with such control over the administrative functions of the trustee as to make of the trustee simply the settlor's representative, no valid trust is established. Whoa. So the administrative function of the trustee is to make the trustee simply the settlor's representative. Then it's not a valid trust. So you have to have some autonomy for the trustee. It can't be controlled by the settlor, or else they're considered just a representative and not a true trustee. Therefore, no valid trust is established. That's footnote 4. Cleveland Trust, that's 1938. Okay, well established. Let's see where we are here. Similarly, while a trust instrument may purport to name a beneficiary, if the settlor reserves a substantial interest or unbridled control over management of the operations that is not for the benefit of the purported beneficiary, the trust may be found to be illusory. So let's see. If the instrument may purport to name a beneficiary, settlor reserves a substantial interest or unbridled control over management that is not for the benefit of the beneficiary. Trust may be found to be illusory. In such circumstances, it has been stated that the settlor remains the owner of the property, and there is no beneficiary. So cases, here we go. A grantor trust is a trust over which the settlor retains substantial control over a trust property or its income, so that the settlor is taxed on the trust income. So be careful. Grantor trust is not good. As to the effect of a settlor's naming him or herself the trustee or beneficiary of the trust. 1990. As to reservation of power of revocation. 1997. Here we go in a 1986 case. A trust was declared as void, as illusory, where the trust was revocable. The trustee's role was merely custodial, and he could not transfer any of the trust property without the settlor's permission. The settlor retained powers so extensive he had the same rights in the trust assets as he had before the trust was created, and the trust which constitutes the better part of his estate was created in favor of his daughters from a former marriage to the exclusion of his wife. Wow. So, yeah, you got to be careful with trusts to try to skirt around certain things. Okay, let's see where we are here. Reservation of power of revocation. So we have some nice forms here. The revocable trust agreement, revocable trust agreements, reservation of power of revocation, and the revocation forms. All contained within your American jurisprudence. Great stuff to have if you can find it these days. I've noticed they've been removing it from libraries for some strange reason. I wonder why. Well, let's continue reading. Back to our restatement. Settlor has the power to reserve the right to revoke the trust in whole or in part. A trust which reserves to the creator or to some other person designated powers of revocation is not, for that reason, rendered invalid or incomplete. In creating a trust, the settlor can reserve to him or herself or grant to another the power to revoke the agreement as to property interests of the various beneficiaries at such times as and on the conditions the settlor directs. So caution, where the settlor makes no reservation in the language to amend or revoke a trust, he or she may not unilaterally revoke the trust. So again, to see here, there's a question here. So it's not about being in layman's terms or in legal terminology. What really matters is what it says right here. There needs to be language to amend or revoke a trust. if there's no reservation within the language of the trust, right? He or she may not unilaterally revoke the trust. You have to say it in a language that there's reserved a right for the settlor to revoke the trust at any time. Then yeah, but if there's no explicit language to do it, and it's not seemingly from the actual words in there that there's an intent that the settlor can unilaterally revoke the trust, then he or she may not. So here's our observation. The right to revocation of the is not a property right. It has none of the attributes of property. So it has to be in the language of your trust, it seems to me. That helps clarify what we were talking about. Yeah, you could alter it, but I mean, that's getting into another aspect. We're talking about if you create a trust, we're just at that level here, creations of trust, that if you have language in that creation of the trust that the settlor has, the right to revoke it unilaterally, then it is reserved. Otherwise, it may not. It's not considered a property right. So the revocation is not considered a property right. It has to be explicitly added. So we have some pretty good ones here in the Florida District 2004. So there's a lot of good cases to look in here. The retention by the settlor of the power to revoke a trust is insufficient, standing alone, to render the trust illusory or testamentary. And as the powers of the trustees to administration of trust generally. So pretty good stuff in here. And here we go back to what we just asked, the reservation of power of modification. Archangel for Truth was saying here to alter it, and that's what we're going to go over right now. So the restatement third, trust, section 25. Trusts in which powers of modification or amendment have been reserved for the trustor are valid. Retention by the settlor of the power to modify a trust being insufficient, standing alone, to render the trust illusory or testamentary. The validity of trust reserving powers of modification or amendment in the trustor and trustees, in the beneficiaries, or in others has also been recognized. There it is. So the retention by the settlor power to modify a trust being insufficient, standing alone, to render the trust. See? So it has to be valid within the trust. Beneficiaries surviving at the time of the amendment. So yeah, we can get some pretty complex at 1940, Massachusetts. So pretty cool stuff here. Let's chat moving here. Okay. All right, we're looking good. Let's continue. And we're at the reservation of life interest or other powers, multiple powers reserved. So this goes here. The model codes and restatements is the third. Trust section 25. A grantor's reservation for all income for life does not invalidate a trust where there has been an actual transfer of properties to the trustees. For life does not invalidate. Reservation for all income for life does not invalidate a trust where there has been an actual transfer. In this regard, the reservation of a life interest to a trustor is not inconsistent with a sufficient present divestiture by the trustor of his or her title to property to create a trust. Although it has been said that the fact that all benefit to another is postponed until death is of weight as to the testamentary character of a disposition of property, thus requiring compliance with the statute of wills. The settlor may reserve to him or herself a beneficial interest in the proceeds from the property for his or her life, and the power to revoke the trust in whole or in part at any time. Okay. We're back. Many extensive rights, other than the power to revoke and life benefits, may be reserved by the settlor without defeating a trust, and thus a settlor may reserve many powers of control, even of disposition and appropriation of the property, without invalidating the trust or rendering it testamentary. So if you remember what testamentary trusts were, we could look at this really quick here, because I think it would behoove us to remind if we have a new audience here too, and I think we're right here next to it. Testamentary trust was right over here. I just saw us passing by it. It might be a good time to look at it. So testamentary trust. Darn it, I saw it here. Here we go. Testamentary trust. See it on screen? Yes. 1832. A trust that is created by a will and takes effect when the settlor, the testator, dies. Also termed trust under will. Okay, so trust under will. It's a will that takes effect when the settlor, testator, dies. So that's we have a good definition now of a testamentary trust. Someone needs to die. Let's continue. Furthermore, the mere fact that the settlor makes him or herself the sole trustee, besides reserving a life interest and power of revocation, does not necessarily render the trust invalid or testamentary in character. An inter vivos trust, remember this is between living parties, will, an inter vivos trust will, I think we call it the living will, may also not be rendered testamentary or invalid by the fact that, in addition to a life interest and power of revocation, the settlor reserves a substantially unlimited right to withdraw or appropriate principal, insofar as the right to withdraw principal has not been viewed by some courts as being much different from a right to revoke in whole or in part. Further, a trust is not rendered testamentary or invalid by the reason of the fact that, in addition to a life interest and power to revoke, the settlor reserves a right to sell the property and appropriate the proceeds. Interesting, and this looks like we're talking about some kinds of investments here. In a grantor's defense, trustor retain power to dispose of trust property. This is in our pleading and practice forms, section 29, under trusts. So this is the reservation of life interest or other powers, multiple powers reserved. Grantor's reservation, all income for life, does not invalidate a trust where there has been an actual transfers of properties to the trustees. So this is some pretty interesting stuff to know here. Trust is not rendered testamentary or invalid by reason of the fact that, in addition to a life interest and power to revoke, the settlor reserves the right to sell the property and appropriate the proceeds. So as the requirement for a valid trust, there be present an unequivocal disposition of the trust property, where the settlor of a trust reserves to him or herself a beneficial life estate, power to revoke or modify in whole or in part, and power to control the trustee as to the details of the administration of the trust. The scheme becomes testamentary as to the dispositions intended to take effect after the settlor's death. Ooh. Beneficial life estate, power to revoke or modify in whole and part, and power to control the estate. power to control the trustee as to the details of the administration of the trust. The scheme becomes testamentary. Interesting stuff there. Valid trust may be created even if the donor retains a life interest and almost complete dominion and control over the property. Valid trust may be created even if the donor retains a life interest and almost complete dominion and control over the property. That's 1936. So well-stating law in 1961. So well-established law, we could say, for discussion of the trustor or settlor as trustee generally. So when we get in these fine distinctions, it's through California law, 1955, and Illinois. So we got some good stuff here. This is Illinois, but it's applying California law. Interesting. Sarasota, Florida, 1968. Great stuff here. And we're getting to the next section is generally. In general, the rules for construction of written instruments apply to the interpretation of trust, so that the meaning of the trust is determined by the same rules that govern the interpretation of contracts, deeds, or wills. You get that? Back to our language, because again, there's no simple answer to this stuff. With American jurisprudence, we want to have an understanding of the foundations, not a slippery cookbook approach. So I think it's important to understand. There was something I want to highlight here. Where did it go? There we go. Again, this one keeps popping up. It's not about the terms, it's about the language. So let's get back to that. In general, the rules for construction of written instruments apply to the interpretation of trust, so that the meaning of a trust instrument is determined by the same rules that govern the interpretation, so the same language of contracts, of deeds, and wills. That's the language you want to use. In construing a trust instrument, the courts are required to subordinate form to substance. So substance has to mean more than the form. So that the words, the type terms don't matter as much as the meaning. How's that sound? A trust is construed according to the law in effect at the time it is created. 2008. As the construction of contracts generally, see contracts, so we could look at that some other time. As a construction of deeds, we could look at American jurisprudence on deeds, which I do have all these at the construction of interpretation of wills. We're not going to talk about death that much here. All right, let's see what we're on to here. Creator's intent. And I think we're going to be leaving off on this section right here, so let's get right to it. The primary rule of construction for trust is that a court must, if possible, ascertain the intention of the tester or creator. And a court's primary duty in construing a trust is to give effect to the truster's intent. The fundamental rule when construing trust is that the intention of the settlor, as expressed in a trust instrument, shall prevail, unless inconsistent with some positive rule of law. It is said that the cardinal rule of law in a trust case is that the intent of the settlor controls the interpretation of the instrument. Cardinal rule of law in a trust case. Man, you pull that line out to support whatever you're trying to say. If it's this, the intent of the settlor controls the interpretation of the instrument. And when the purpose of this trust is ascertained, that purpose will take precedence over all other canons of construction. Nice language, tight. In interpreting a trust, a court's initial focus must be on the terms of the trust. Accordingly, courts look first and foremost to the language in the trust. and interpret that language to effectuate the intent of the settlers. You see how we have a fully constructed sentence here, right? To effectuate the intent of the settlers. We're defining everyone here. It is the grantor's intention which exists at the time of the execution of the trust instrument, which controls, not one thereafter formulated and not expressed in the instrument. However, the intention of the settler at the time of creation of a trust may be shown by facts occurring after that time. Wow, footnote 9, what could that be? 2001, Arkansas, Wisner versus Burns. Heavy stuff here. Practical guide, the determination of the ultimate fact of intent of a trust settler rests with the court. Get that? So you have to be able to prove to the court, and we can do it with what we just went over here with the common law approach, that it's the intent, the language of the intent done by the original purpose for the trustor. All these things come into play. Everything we've read is a way of articulating and expressing in the written word what your argument is going to be to a court, so it can move in your favor. In construing a trust document, the fact that the form of assets may change over time does not defeat the settler's intent of disposing of the assets. So the form of assets may change, but it does not defeat the intent of disposing of the assets. When words of recommendation must be followed to carry out the clear intention of the settler of trust, such words are regarded as words of command or direction. What words? When words of recommendation must be followed to carry out the clear intention of the settler of trust, such words are regarded as words of commands, imperatives, or direction. 12. 1998, Ohio. Great stuff. So let's look at our cumulative supplement here. When a trust instrument must be construed by a court, the court attempts to discern the settler's intent in light of the facts and circumstances existing at the time the instrument was executed. See, they want to think of it, you got to go back in time of the circumstances at that time, not the current circumstances, when a court is trying to construe the intent of the settler. If the settler's intent is clear from the plain language of the trust instrument and not against public policy, as we saw in the earlier section, courts must give effect to that intent. The intent, one who creates a trust, is to be determined by the language he chooses to convey his thoughts, the purposes he seeks to accomplish, and the situation of the several parties to be benefited by the trust. So again, I don't know why we keep coming back to this, but I think this is part of what it's all about. Can a trust be written in layman's terms, or does it have to be legal terminology? Well, the intent is determined by the language you choose to convey your thoughts, the purposes seek to accomplish, and the situation of the several parties to be benefited by the trust. So I hope this is getting very clear by now what language to use. Okay? When a court reviews a trust, its primary duty is to ascertain within the bounds of the law the intent of a settler. When determining the settler's intent, an inter vivos trust speaks from the date of its creation, not the date upon which assets are distributed. And courts ascertain the intent of the grantor by looking at the language used in a trust agreement. And supplement, and we have a basic tenet in the construction of trust is to ascertain the intent of the settler and to give effect to this intent. Beautiful stuff. Unless contrary to the settled principles of law, the intentions of a trust settlers must control in actions involving the trust. All other rules of construction must be subordinate to determining the settler's intent. See, all of the rules of construction, language, legalese, are subordinate to determining the settler's intent, their value being as aids in ascertaining that intent as precisely as possible. Threshold inquiry in any trust case is to examine the terms of the trust document. Examine the terms. You see this? Examine the terms. So you have to figure out your language by your intentions. So again, language is everything. The construction, the words of the trust instrument is everything of the trust. As long as it's within the bounds of law and public policy, those words are everything in whatever language you choose to be able to convey your thoughts. So next time we'll continue on some of the more esoteric ones like the construction of unambiguous trust generally, and we'll get on to other more detailed aspects of trust. But I think up to today, we've really gotten into a really good understanding here of the creation, the powers, and the intention of trust. And hopefully everybody has been able to acquire some type of foundational understanding of what trusts are, because I feel that it's poorly understood. I think the foundations of it are because of the way they've been misconstrued and abused and used in ways that are let's say, not so savory, as there are so many good intentions for trust to avoid a lot of nonsense and unnecessary complexities. That's the purpose of trust, and to be able to have the ability for us to easily create them, we can see now that it doesn't require anything special other than a clear way of using words to communicate the intent of the settler of the trust. And the powers are within the bounds of the law and public policy by the language that's used in the trust. And the intentions have to be very clear and to effectuate these powers and to keep the validation of the trust intact. So I hope everyone had a good time enjoying this deep dive. Oh, there goes my chat. Finally, gosh. All right, did I? Oh, there I am. Okay, good. I think I was out for a while. I don't know how long. I hope nobody missed anything. Usually in the replays, the buffered stuff catches back up somehow. Policy thing. Yeah, so it's not really the policy so much. Public policy is common law. Again, we don't do things, public policy is causing loss, injury, and harm, and those kinds of things. Then we have statutes that might articulate that more precisely. But it's spell casting in a way, but it's a good way. I mean, if everyone's casting spells, you might as well cast some spells in your favor here to protect your property, which is what trusts are about. It's about property and about having a way to take title of property away from just one individual and have control distributed in a way that's constructed to be beneficial for more than one from the use of property. Again, we are looking at restatements of law in the execution of trust because it's supposed to guide the laws to work to better help us with the life, the purposes of life. And that's where the law and life and meaning come into play. And trust are one way of us bridging that gap. Yeah, it's policy. Yeah, great. Yeah. Well, hey, I'm glad you guys all enjoyed. We had a lot better quality than the last time. I think I had a bad stream out on it. I'm gonna go and edit that one down and get rid of the dead space out of it, so it'll be easy for others to review in the future. And hopefully, we're building up a good a good little catalog here for reference. In the future, I also plan to go through and catalog these presentations here with timestamps and particular topics for the ones that really are hitting home, so that you can easily get back there and get right to the stuff, kind of for those that didn't take notes the whole time, which I know it can be hard. But since I have, and I can do that, I can go back and find the timestamps and post them into a pinned comment for each of these at some point. And that way we could have it like an index or a table of contents to get to, because these can be 2 hours long easily. Yeah. And that way it'll be more accessible, and we can get to the parts that we remember, but we just wanted to get back to for specifics. And again, I have all the references that I'm reading from in here. So for further investigation, further research, the references are right there. Just take a screenshot, jot them down, and hit the law library, and you can find out everything you need to know about trust and more. So again, thanks for joining me on this journey through American jurisprudence, and have a happy Thanksgiving to everyone. Remember, this is the best way we can really show thanks for those that really suffered and died and made a contribution for posterity, to have this style of American jurisprudence that's only practiced here in this country. I think this time of year is very fitting for us to really put a salute out to those that really support this style of justice for all here in this country, so that we can have the type of peace secured that only jurisprudence can do. Again, I thank you all for coming, and I'll see you on the next one. Peace out.